We're on section 13, which deals with the rule on counterclaims, which is rule 13, and also deals with various cases on interference with real property rights. So first we're going to look at rule 13, dealing with counterclaims. As a general matter in litigation, and I usually do plaintiff's work, not defendants, but if you're doing defendants, and I think if I were defending more often, I would think about what I oftentimes think is the right strategy is the best defense is a good offense. And so what you really do need to look at is to whether your client has counterclaims that they can advance against the other side, both from a standpoint of strategy as well as oftentimes a standpoint of necessity. But the fact is that if a plaintiff has something to lose, potentially it makes them reassess both the strength of their case and the decision as to how far they want to go forward before they settle. So Rule 13 comes into play because we have two different types of counterclaims that can be filed. They are called compulsory counterclaims and permissive counterclaims. Compulsory counterclaims, and the reason you have to take a serious look at it is because if the counterclaim that your client potentially has is a compulsory counterclaim, then what that means is it must be asserted at the time the complaint is filed against your client, or it is potentially forever lost through res judicata, that the claim has been adjudicated fully, fairly, and with finality. And it's not just that claims that were advanced, but claims that could be advanced. So if your client has a compulsory counterclaim, they must advance it in Massachusetts and under the federal rules, unless it arises out of an auto accident, and that's actually a completely separate rule because of the rule of subrogation as a general matter. When your insurance company pays you off for your claim, they then have the right to pursue relief against the person that may have caused that accident. Under those circumstances, when the insurance carrier does it and the like, the rules are slightly different. But for the most part, when we're talking about compulsory counterclaims, if you do not bring a compulsory counterclaim, you are waiving your rights to bring it and likely foreclose through res judicata. What makes something a compulsory counterclaim is that it arises from the same set of facts or circumstances as the claim that is brought against you. Because it arises from the same set of facts or circumstances as the claim that's brought by the plaintiff, if it is not asserted, it's forever lost. Because it arises from the same set of facts or circumstances as the principal claim, it doesn't need a separate basis for subject matter jurisdiction if we're in federal court, or in state court for that matter, but subject matter jurisdiction is more oftentimes difficult to meet in federal court than it is in state. But if it's compulsory and not asserted, then you've waived your rights to bring it later on. And obviously, if your client is going to do that, that should have been a conversation between you and your client about foregoing such a claim. The other part of the rule deals with what we call permissive counterclaims. Permissive counterclaims arise from a different set of facts or circumstances than the principal claim. And because they arise from a different set of facts or circumstances than the principal claim, they do not need to be asserted at the time the complaint is filed. If they are asserted, because they're permissive, they can be asserted. If they are asserted, they will need a separate basis for subject matter jurisdiction because, again, they arise from a different set of facts or circumstances, so supplemental jurisdiction won't cover those claims as a general matter. They would need their own independent basis. If they are not asserted, you can bring them at a later point, and the court, oftentimes on permissive counterclaims, because they deal with the different set of facts or circumstances, is certainly not going to go out of its way to try and extend the jurisdiction to it if jurisdiction doesn't exist. It's important to understand the difference between one that arises from the same set of facts or circumstances as the principal claim and one that doesn't. The problem is that definition is a lot more elastic in practice than one would think. And so if you think it's a close call as to whether it arises from the same set of facts or circumstances as the principal claim, then in order to cover your own back end, the fact is that the likelihood is that claim should be asserted along with your answer to that complaint. Because the failure to assert it, if it's later determined that it was in fact a compulsory counterclaim, you have waived your rights, your client's rights, and your client may likely be looking for redress from you because that should have been a discussion we had about whether the client is choosing to forego certain claims And so you need to recognize that it's, when we get the complaint, we're not just thinking about potentially moving to dismiss or filing an answer, but we are also looking, and should be looking, at available counterclaims that you can assert, both from a standpoint of strategy, because again, the plaintiff now risks something going forward, but also from a standpoint of appropriate practice, because a compulsory counterclaim that's not asserted is waived, and that potentially raises issues of malpractice and the like. And certainly, at the minimum, you should have had a discussion with your client regarding what rights they're potentially foregoing there. A lot of times in contract disputes, even basically virtually any matter, there may be a basis to assert a counterclaim of some sort, and you've got to think about what that might be, and you've got to do some research on it. And if it's there, it's certainly good practice to assert it, and it may be necessary from a defensive standpoint of protecting your own back end. That the fact is that if there's a credible claim consistent with Rule 11, the likelihood is it should be pled. Rule 13 allows you to do it, and proper practice suggests that you take a hard look at it, making sure that there aren't counterclaims that need to be asserted or waived. Anyone got questions on counterclaims? Generally going to be asserted. Go ahead, same time as your answer.
You never, like when you want to do a counterclaim, and you may want to, because like you said, the best defense is good offense, but you can't reach too much because you can't throw a Rule 11.
No, whatever you file has to be consistent with a Rule 11, because otherwise you're potentially exposing yourself to sanctions on that end. But you know, whether it's an employment contract, whether it's a neighbor dispute, as we see in some of the cases today and the like, oftentimes that there are, both sides would see wrongs done to them. The question becomes, are they colorable claims that in good faith can be asserted? I would not go out of my way to fabricate a claim that there's no basis in law or facts to assert. That's obviously going to get you into more trouble as well. But a lot of times there are situations where when you sit down and have the discussion, if it's one of these neighbor disputes, or if it's let's say take the car accident example, who's at fault, who caused what, both of them have some damage. Take kind of a common example where you do see it, people get in a fight, someone gets hurt, one person decides to sue. The fact is, it's almost universal that there'll be a counterclaim in response to that claim, arguing you started it, you caused me damage, and both from a standpoint of civil and criminal context, usually the countercharges mean sooner or later we're likely going to be washing these things out, because again, the best defense is a good offense. And you'd be surprised sometimes when someone comes in and has a discussion with you and they feel they have a claim, and you talk to them about it and you say, well, let me, before we're going forward, I do want to explain to you, and again, I think this is part of your obligation. They potentially have claims that they're going to assert against you, and that sort of throws a lot of cold water on the whole discussion, because, well, why could they possibly sue me? Well, the fact is that if you're out there fighting with your neighbor, or if you've breached the contract and you had an agreement to provide X, Y, or Z and you haven't done it now, it's not just necessarily you have a claim, but because we're lawyers, we look to see what the legal rights of all the parties are. And the fact is, when people realize that they potentially could be sued by asserting the claim, and they can be, obviously, because Rule 13 provides for that, it provides a relatively easy means of being sued, right? It's not necessarily you have to think about filing the complaint, think about paying the entry fee, really put your ducks in a row. The fact is, you have facilitated a process that now means that you could be countersued for whatever you've brought. And that's a discussion that the client needs to be aware of, because it's one thing to think that I'm going to get money, it's another thing potentially to think that I could lose here. And again, it's very common that counterclaims are filed, both from a standpoint of strategy and necessity, depending on how it originates. And oftentimes, in the real world, there are two sides to every story, and it's usually both sides feel that they've got something that they feel needs to be redressed, and counterclaims allow for both sides to be able to advance their claims. And then at the end of the day, the court can resolve the entire controversy at one time, And so that's why the rules allow and encourage the pleading of compulsory counterclaims. And in fact, it makes sense from the standpoint the court's going to hear those facts anyway. They might as well resolve it all at once. But don't go out of your way to invent actions that don't exist, either factually or legally, because obviously that's going to run you afoul of Rule 11. It's also going to make for you to have a reputation that you're an unethical lawyer. On the other hand, if you've got an employment dispute and it's got some type of non-compete, there may be issues that both sides feel that the company wants to prevent your client from working for someone else, but at the same point there are likely commissions and other items due that the company's withholding, pension, profit-sharing benefits and the like. And so what that means is that you better bring a counterclaim to resolve those issues as well. And again, the company has to rethink how far they want to push this, because for a lot of employment violations, there may be statutory awards of damages with multipliers and attorney's fees for discrimination claims, withholding wages where they're rightfully due and the like. Those oftentimes will provide multipliers to the actual damage awards. Another question?
No.
Anyone else? Let's talk about Peters versus Archambault, which is our first interference with real property rights. And as I said to you last time, I think this is an area where people frequently litigate. I think, well, I don't think it is. In my experience, it is. And I've had a number of different cases in this regard. I think partly the reason it is for most folks is it strikes them both from the standpoint of their largest asset that most of us own is our home, and the second part of that is that's where people spend an awful lot of time, and that when that time is disturbed in some fashion, people don't oftentimes suffer it lightly, and the fact is we end up with a significant amount of litigation that concerns different aspects of real property issues and the like. So the first one is Peters versus Archambault. What is the issue with respect to what these neighbors are fighting about in this case?
Your building's on my land.
Your building's on my land, move it, right? Not uncommon at all, actually, especially this is down in Marshfield, right? So you've got relatively small lots near the ocean, near the beaches, in the areas and the like. And the other thing is when a lot of these houses were built, they were done cheaply and quickly, and it is not uncommon in not just this type of development where you see it a long time ago, but I had one out in Braintree, even the development I live in. If you looked at what you would think were people's lots, they don't look like that at all, because instead of being straight, they're all like this. And so the fact is most of them are cutting their neighbor's front yard or backyard. And at some point you're going to have significant disputes about that. The one in Braintree we had was a development that when they started developing it, the builder hit ledge. And so what he did is he, in his own mind, shifted all the lot lines 15 feet and just built everything 15 feet differently than what the plan provided. And a lot of the driveways, as it turns out, are not on where they should be. They're on the neighbor's land, and that's fine until someone either decides to sell or that they fight about something and someone goes out and gets a survey done. We had a survey done here, and there was, in fact, an encroachment on a relatively small lot, oceanfront lots, obviously then and now very valuable. Both lots were registered land. What is that, registered land? Because that's specifically for Massachusetts, that has some real import to it. What's registered land? No one?
I thought it may record it.
What?
I thought it may record it.
What's that mean? What do you mean by you thought it? What do you mean recorded?
Like it's recorded at the Register of Deeds.
Well, isn't everything going to be recorded at the Registry of Deeds concerning an interest in land at some point? Doesn't it have to be?
Yeah,
Huh?
I think so.
You think so? You've all had property, right? So things have to be recorded at the Registry of Deeds. How is that different than registered land? Not a clue?
Well, it's immune to adverse possession claims.
That you got that from this case?
Yeah, I just read it.
If it in fact is registered land, that's true, and we'll talk about that in a minute as well, that aspect of it. So what do you think it is that makes something registered land? You looked it up, Matt?
Yeah, I looked it up.
Okay, what is the difference? Because, by the way, it then becomes important because there are additional protections to it. So if your client is buying registered land, obviously from the standpoint of this case, it's to some extent of greater value than it might be otherwise. So what is registered land?
You get a declaratory judgment that the land's free of encumbrances on the title.
And who gives that?
I guess probably the land court, I don't know.
Yeah, no, that's right. Okay, so registered land is a process of where the land court has determined not just who owns the land, but what encumbrances are with it and what exists with respect to both the title and the history of that piece of land. It is a court process, just like a civil litigation process would be, but this is now where the court ultimately makes a determination as to the ownership, and not just the ownership, but encroachments and anything else that might exist on that land, any liens. And if the court, at the end of the day, through the registration process, makes a determination, that's it. And so with registered land, you get an actual certificate of title, like you do for your motor vehicle. And the way that land is then exchanged is both with the deed and the transfer of the certificate of title. It is different than land that has not been registered, which would simply be filed at the Registry of Deeds when you transfer it, and your title would then be obtained by making a title search, hopefully uncovering whatever liens there are, and as you purchase that property, then those liens would be paid off. But registered land, the certificate of title will show those attachments. It also makes it much easier when you do want to do a title search or when you do want to transfer the land if it is registered land. There's also, because it's a court process, as you see here, there are additional protections that come from it. The registered land process, though, if you were to take a parcel, and sometimes what you do, someone will come to you and there'll be a problem in the back title somehow. I had one, I represented some folks, as it turns out, their great-grandfather had an interest in a piece of land. He never signed off on it, and the land had been transferred a couple times, and now someone wanted to commercially develop it, but the fact is that no one had ever taken care of his interests in the property. The process that what they were trying to do was cut off some of those rights, so they were registering the land to try and now have it available for commercial development. And the fact is, my clients were named as parties to it because they had an interest in it as his descendants. And the fact is that they had to satisfy their interest with cash in order for them to be able to release that. A lot of times what you do is, it's not just old land, is that if in the process of it being transferred or developed, someone finds a flaw in the title, you may take it to the land court in order for them to issue a declaratory judgment as to whose land it is, what rights are attached to it, and then it can be transferred after that much more easily and without the encumbrances and without the other title flaws potentially, which means it's easier to then get lending on and everything else. This piece of land would not have been developed if they didn't somehow extinguish the rights of this family, because somewhere along the line no one took note that the grandfather had an interest that had never been released, but had been transferred a couple times since then. The registration process is in fact another piece of litigation. It's a declaratory judgment. Parties are named, they get to come in, they get to litigate their various claims if they have them, if they want to pursue them. But at the end of the day, the court's going to issue a judgment as to the title to that real estate, and then it's registered. And as you can see in this case, registered land in Massachusetts certainly has additional protections to it. So this lot happens to be registered, which we'll come back to. But it's a part of the house is built on the plaintiff's lot. The total area is 4,900 square feet, not uncommon for these small lots, especially in beach areas, 5,000 square foot lots. Each lot has a frontage of only 50 feet. The encroachment contains 465 square feet, and the building extends 15 feet 3 inches onto the plaintiff's lot to a depth of 31 feet 4 inches. The court said that there was no estoppel or laches. What are they? What's estoppel? What's laches?
Claim preclusion.
Well, that will be collateral estoppel. This is another form of estoppel.
Issue?
No, issue preclusion is collateral estoppel. What would this estoppel be? Go ahead, Jonathan.
I remember laches being the, like a delay.
Like?
An unreasonable delay in asserting your, what? Simplify?
I don't like the like.
Wait, what?
I don't like the like.
Like what?
Like that. You said,
Oh, it's an unreasonable delay in asserting your rights that causes prejudice to the other side.
very good. That's laches, right? Laches is an unreasonable delay in asserting your rights that causes prejudice to the other side. The reason it doesn't usually, it's different from statute of limitations. The statute of limitations is a fixed time period in which to bring your action. But laches is more elastic than that, and especially in continuing trespasses or continuing nuisances and the like, every new day is a new violation. So even though if it's a tort, your statute of limitations would expire in 3 years, the fact is that every day it exists, the time period runs anew. You may be foreclosed from collecting damages beyond that 3-year period, but it doesn't mean you can't collect for the 3 years immediately preceding the bringing of the action. That's why we have to look at laches. Laches is not a statute of limitations argument. The argument is that there's been an unreasonable delay in asserting your rights, and it causes prejudice to the other side. It is what we call an equitable defense, and since this is an equitable action, you can use it. What's estoppel then? What's estoppel?
Just stops you from doing anything. It could be,
But why? When does an estoppel come into play? Go ahead.
Usually there's reliance on something,
Right?
and then stop being basically you're barred from bringing that action.
Because of your actions, you are stopped or prohibited now from taking advantage of your actions and using it to harm the other side. I'll give you what I think is a good example of estoppel from the beach up here in Salisbury. All the houses are close together, right on the ocean. Client wants to build this elaborate stone wall and stairs up to the side of the house. Neighbor sees him out there and says, "Hey, what are you doing?" He says, "Well, I'm going to have this stonework built and nice stairs and a little garden down here, blah, 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 blah." And he says, "Well, I think you're too close to the line." And he says, "No, I think I'm okay." He said, No, I know where the line is. I'll stake it out for you." And so the next door neighbor comes out. He stakes it all down the way. Client then has this elaborate stonework done right to where the neighbor said that lot line was. When he's done with tens of thousands of dollars worth of stonework, neighbor comes out and says, "I think that's too close." And he says, "I put it right where you said you wanted it, right where you said the line was." Neighbor has it surveyed, finds out that this entire stonework is 6 inches over the line where the neighbor thought it was, encroaching on the neighbor's land. Neighbor says, "Tear it up. I don't want it there." Estoppel says that at least you have an argument that based on that you changed your position based on what they had told you. And based on that, now they should be prohibited from benefiting from their now change of position, saying, no, that's not where it is, it's somewhere else. Estoppel means you have done something that means that you should be prohibited from taking advantage of your earlier actions. And therefore, they're saying here, in this case, we've got no estoppel and we've got no laches that we're aware of. So the question, it's a straight-on question, is do we remove the structure? So is this a trespass or is this a nuisance? Because it's an encroachment, right?
What do you mean nuisance then?
Is it a nuisance? Yeah, because I'm going to ask you to define it again. Private, I assume this would be a private nuisance, which I'm not sure we define. Or is it a trespass? What's the difference? Do we know what a trespass is? You guys know you're going to be tested on this again, right? So what's a trespass?
It's an unlawful entry upon another person's property.
Unlawful entry onto another person's property. So is this a trespass? It is?
Isn't that building permit?
By the way, are you all good with that definition? And I'm,
Intentionally going onto someone else's land without permission.
intentionally going on to someone else's land without permission. Well, what he said, what do you think about that, Brian?
I think the intentional, yeah, that's probably good, intentional unlawful entry.
An intentional unlawful entry.
But you can trespass without being intentional.
So tell me what it is then. I just want to know what trespass is. So,
You don't have to intend.
Yeah, just intend to where you're going. You
So-
have to have intent.
so you got a definition for us, Charlie?
Yeah.
Okay, what's it say? What's a okay, so what's a trespass?
Entering another person's property without permission of the owner or agent.
Okay.
And you're there without lawful authority,
Okay, so it isn't unlawful entry onto the land of another without permission.
causing damage.
Oh, so you got to cause damage. So if I just walk through and don't cause damage, it's not a trespass?
Well, causing damage, it says that the use of the property alone is a sufficient showing of damage. So if you're using that property, that's damage.
So just walk, so I don't need to show damage, because if I walk through it, that the damage is presumed?
Yeah, I guess so.
So if I get lost, sometimes I get lost behind the house? No, I do. Well, there's all woods behind the house, and then I go up, and I don't want to go all the way back, so I just cut through someone's yard, way in the back. That's a trespass?
Well, that's where the law, like,
Uh-huh.
that's where you kind of, that's where you,
Well, it was lawful until I went through their backyard, right? Is that what you mean?
Yeah.
So that's a trespass?
Yes.
If you're intentionally trying to cut the path and you're using.
Well, I'm not trying to cut the path, I'm just trying to get out of the woods. So is that trespass?
It is a trespass. But I thought trespass, there didn't have to be intent. For example, if you jump over the road to not get hit by a car on someone's property, you're still trespassing, but you had no intention to do so.
Well, that's the unlawful. You have exceptions to trespass, such as the emergency.
Shouldn't we know this?
Yeah.
You used to? Because you're probably going to need to know it again.
Yeah, comp is coming.
Well, the bar exam, for one, and people have these problems. So this is not a trespass to land, or, I mean, what is it? Or is it just, because it doesn't, the case doesn't really talk about trespass or nuisance, does it? Or,
I don't think it's a trespass because it's permanently on the property.
so you can't have a permanent trespass? Because I think you can.
Pretty sure, yes. I think it's called trespass to, I think it's trespass to train.
So it is, so it potentially is, it is a trespass. Could it be a nuisance too?
It's the enjoyment of the land, sure.
It does interfere with the use and enjoyment of the land, right? And that, because I've got a note here, private nuisance, if that's what this is, it says is a non-trespassory invasion of another's interest in the private use and enjoyment of the land. Oh, okay, but you were just telling me this might be trespassory. And the private nuisance says is a non-trespassory invasion of another's interest in the private use and enjoyment of the land. Does it create a substantial or unreasonable interference with the use and enjoyment of the property of another? Because clearly, 465 feet could interfere with the unreasonably with the use and enjoyment of someone's land? Or is this a trespass? This is a trespass. If you had the case, by the way, I mean, I'm not sure you're the only ones confused about where the line of demarcation is here. If you had such a case, would you plead both? Potentially trespass and nuisance, two separate counts? What were you going to say,
I just had
Charlie?
a quick question.
Go ahead.
Could you repeat the second part of that? I got that as a non-trespass.
Non-trespasser, I have, private nuisance is a non-trespassory invasion of another's interest in the private use and enjoyment of the land. And then my second part was, does it create a substantial or unreasonable interference with the use and enjoyment of the property of another?
Can inanimate objects trespass?
I don't know, you're the one that had torts and stuff in property, right? I had it when the world was flat, so you should know better than me. So can you? Can't you? Does it, can an inanimate thing trespass?
Yes.
Like if I shoot a rocket and it goes on to someone else's land, right? Is that trespass?
Yeah.
It is.
Yeah.
Okay, so what do we think? Do we think this is a trespass or a nuisance? What have you? Did you guys define trespass well, Charlie? What was it?
Entering another person's property without permission of the owner or his agent and without a lawful authority.
See, I think the last part all sounds good, but is this an entry? I guess someone had to enter when they built it.
Unlawful intrusion.
Unlawful intrusion.
That interferes with a person.
Say what? Take your hand away from your mouth when you talk.
Unlawful intrusion that interferes with a person's
An unlawful intrusion that interferes with
property.
person's property. So then would you think that this is a trespass?
So the whole,
Speak up, Andrew.
still on the whole inanimate intrusion part.
But I thought we decided a rocket could be a trespass.
It's the house.
Huh? Okay, but somehow this house got put here.
I don't know. I remember a case that was. I remember what the guy was doing. I think he was hunting or something like this, and there was my memory. But he like made his foxes or his dogs go onto somebody else's property, and like take like the ducks or the rabbits or something like that. And it was held to be a trespass even though the guy wasn't physically there. So if we take, say the house as the person making the object go onto someone else's property, it would be a trespass, especially since the definition of nuisance, it says a non-trespassory intrusion.
Invasion.
So I think it would be a trespass.
Okay, then I have a question.
Go ahead.
Who's trespassing then? I mean, this person who bought the house.
That's Jonathan.
Okay. The person who bought the house, even though it was on somebody else's property, so it's trespassing.
Well, it goes back to your question. Does it have to be a person or can it be the thing? Can it be this 465 square feet that in fact is constituting the trespass?
Yes.
Wasn't there a case in property with like a shed being on someone else's land and that object was trespassing over? So if a shed can trespass, then why can't stairs?
What about that? By the way, sheds constantly are issues. They usually come up when someone's selling the house and they do what we call a windshield survey. Someone looks and says, that shed's not there. Sheds constantly are an issue because everyone wants them as far away from the house as possible, and the problem is they just keep pushing them, and all of a sudden, it's not where it should be. Sheds, decks, driveways, potentially all raises problems along these lines. This is the portion of someone's house, though. Let's get to the case. It says that you can't have. Well, first of all, it is an encroachment. It clearly exists onto the land of another. It's been there a while, and that's one of the arguments. Has it been there long enough to establish adverse possession? Tell me, what is it? What is adverse possession?
Open, continuous.
What? You got to speak up.
Open, continuous. What's E?
Adverse.
Actually adverse.
Hostile and notorious.
notorious, and statutory.
Continuous for statute.
Okay, wait a minute though, because you got, I'm hearing about 8 and I didn't, I learned 4, I know you guys learned 5. But so can we see if we all get close to the same page? Open, right?
Continuous.
Continuous.
Exclusivity.
Exclusivity.
Actually adverse.
Actually adverse. That's what we learned, I think, is hostile, no? Or you learned?
Same thing.
Synonymous.
Okay. So,
Notorious.
oh, you already did that, didn't you? Open, this is, okay, listen, this is what I learned, and you can tell me what's different. Open, notorious, hostile, and exclusive. And you add continuous to it, but it's got to be 20 years. So what's the matter with that? Open, notorious, hostile, and exclusive.
Statutory.
What's that mean, statutory?
21 years.
Statutory
What?
period of
It's
time.
a statutory period of time.
Okay, but so why do you need continuous?
Because you can't get break.
Yeah, you can't stop.
Well, but then you don't have the statutory period. Because I'm hearing a lot more than 4 or 5.
You can, if someone does it for you, you can.
Right, you can tack onto someone else's, right? Okay, so tell me what you guys say. By the way, do you agree that it's supposed to be 5?
Oceans, yes, oceans.
Oh, okay, so you've got a mnemonic that's supposed to work. Oceans, by the way, sounds to me like that's 6.
It's a lot.
Okay, so wait a minute though. No, seriously now, right? You're gonna have to make this analysis for the bar exam, and also you will have cases. I actually had one. When I went to the zoning board, they laughed. Oh, we haven't heard adverse possession since law school, but it does happen. So tell me, how many elements am I looking at here? 5 or 6?
6 if you do oceans.
So do you all agree to 6?
So sorry, sir.
Okay, so you're saying there's 6. Okay, so O is open.
Yeah.
Right, is that the open? Okay, so we agree on that. And the C is continuous.
Yes.
Okay, so we're on the same page. E is
Exclusive.
exclusive. Okay, so we're still relatively on the same page. A is
Adverse.
adverse.
Actually adverse.
Tell me what that means, because I've had this discussion with both Casaro and Malaguti before. Tell me how that is different than what OCE, you're exclusive. How is the actually adverse different than exclusive? Because to me, if it's exclusive, then I'm adverse to everyone, aren't I?
I think
It's not allowed.
Wait, one of you at a time.
I think there's a distinction between the exclusivity to the public, as if it's your own land, and then the adverse is adverse to the actual owner.
That's correct.
So it's like a little distinction there. Because I mean, exclusivity could be to everyone, including the actual owner, but I don't know.
Well,
that's
but see,
how
to
we're
me,
talking
just
about it.
thinking like a lay person would, exclusive should be just as its name implies, or it's not exclusive. So if it's not exclusive to the actual owner,
But if both of you are I don't know. That's just how.
go ahead.
Adverse means that it's, you don't have permission to be there. The owner of the land didn't say, oh yeah, you can stay here.
Actually
Because if
adverse.
that's
Okay, so you
true-
use that instead of what we learned as hostile.
Because if that's true, then there's
It
not,
just replaces hostile.
Okay, you're using actually adverse to replace hostile.
yeah.
Okay, because I tried that case too, is we had a case where it was, and we tried it in the land court, they tried to acquire adverse possession, and the argument had been, is the previous owner said, no, you can park and use that section of my land way in the back, and you're welcome to park there, but it's permissive use. And then when the new owners said, okay, off, what they were arguing is, no, we've had open, notorious, hostile, and exclusive use of that land for over 30 years at this point. 15 of them were with permission. And so it wasn't actually adverse, it was with permission. So wait a minute, OCE, so actually adverse, well, you got
I
something?
have them for you, yeah.
Okay,
Oceans, I remember, was a bad mnemonic because it didn't accurately show the 5 ones. It's open, actual, exclusive, hostile, continuous. That's a Fury Perry review.
okay, so you're down to 5 though.
Yeah.
So wait a minute though, we'll come back to your point in a minute, because OCEAN, notorious?
It's notorious.
See, that the ocean involved multiple terms, that's why I didn't look.
Well, but that's again, okay, that's what I'm gonna ask, like, well, how is the N different than the O? The O is open and it is notorious, how are they actually different?
I think you're holding
Like I
yourself,
said, everyone's so fast.
you're holding yourself out as the owner of the community, and if you're just open, I mean, you could be walking around the woods and you wouldn't be necessarily hiding because you'd be visible, but if you're open and notorious, you're holding yourself out to the community as the actual owner.
Well, but, so, is this the end actually necessary? Suppose I'm in a rural area, I have fenced that area in, it's been mine, used for 20 years, and not everyone knows who owns the fence. Does that still classify as notorious then?
They have to make it known.
Huh?
Because notorious mean you have to make it known.
I don't know, I'm asking you, because we didn't use the N. And so what's the S, by the way? Let's just finish your existing mnemonic. What's your S?
Statutory.
Oh, statutory period, you're 20 years or more, okay, so we can go, I can live with that. So, Charlie, you have a different one. And which one are you getting rid of, or are you changing them all around again? You don't have oceans?
No.
So what do you got, what do you have there? And you have 5, not 6.
Instead of the N, there's an H. So it's.
So, instead of the notorious?
Yeah, it's.
And what's your H? Hostile?
Hostile, yeah.
Okay, but so then you're skipping which one? Because you said there's only 5 in that one. Give it to me.
Open, continuous, exclusive, actual, hostile.
Just give it a second.
So you're not using the statutory period, but you obviously open, notorious, hostile, exclusive.
Continuous encompasses the statutory.
Did you use continuous? Yeah, I would think, I could see where you could argue that. I mean, if it's got to be continuous for whatever that period of time is that the statute provides for. In Massachusetts, how long is it? No, 20 years, right? 20 plus. 20 plus something, not 21. Can I use adverse possession in this case to defeat the claim that the piece of land has to be removed? Because it's been there since what, 1940 something, right? 1940, building permit was 46, this case is 72, so it's been there 30 years. Can you use adverse possession to defeat the claim of the encroachment?
Is this registered land?
In this Peters versus Archibald, it is in fact registered land that the encroachment exists upon. What's the rule in Mass?
Can't.
You cannot have an adverse possession claim against registered land, as Marsha started us off with. It is one of the significant protections for registered land, and that's the purpose of, at least one of the reasons why the court declares what the rights and obligations with respect to that piece of land are. And you cannot have adverse possession against that land. By the way, if the land isn't registered, and you've got a situation like this, again, this is something that, when you talk about counterclaims and the like, that you should have a discussion with your client. It's one thing to have this neighborly dispute. We ought to sit down and figure out what's going to likely take place here so that you understand. If you think the neighbor is going to readily tear their house down because you want it down and you guys have had a fight, the neighbors fight fire with fire. And so the fact is that you need to know how long it's been there. You need to know how it came into existence, because we're going to argue estoppel. We're going to argue adverse possession. You're going to argue whatever it is, and you know, because that's what lawyers do, right? We represent the adversary as zealously as we can. The fact is that you may be creating a problem that people aren't comfortable with at the end of the day. And by the way, sometimes with a lot of these, there's going to be no good solution if they can't make peace, if they can't get along with each other and exchange some deeds and the like and some easements. We've got big problems. I had a deal go bad down in Quincy, even though the driveway had existed for 50 years, right where it always had been. But the neighbor's land was registered land like this. And I said, listen, we're not going to change anything. All we want to do is just create an easement for what's always existed. And she said, no. She said, someone told me easements are bad. I'm not going to do it. We had to walk away from the deal simply because there's just no way you could make it work, not within a reasonable time. You can't have adverse possession against registered land. The fact that it had existed for 50 years and no one was going to look at these houses any differently, it's a relatively simple process to have an easement to provide for access over 5 feet, 10 feet, 15 feet of land. She was having none of it, and the deal exploded as a result of it. So the fact is that this is an important case because it does teach us a few things about registered land and the like that you should be aware of. So you can't have adverse possession against registered land in Mass. So what should happen with this 465 square feet encroachment? What's that, 20 by 20 or thereabouts? 20 by 22? 23 maybe? What happens? What does the court do?
They may take it down.
They make him take it down. Tear it down. Gone. Would it make a difference to you if this 465 square foot, 20 by 23 foot encroachment, and it's not, it's 15 by something else, but it doesn't make a difference. What if it contained the only bathroom in this other house?
Good luck.
Is that tough luck? So you would potentially render the other house uninhabitable and the lot unusable because frankly, in a 5,000 square foot lot, with Title V and the like, the septic requirements near the ocean, you may be completely out of luck with any attempt to rebuild or to put a bathroom in there that's going to comply with modern sanitary requirements. Even if it's the bathroom, out it goes, tear it down.
Well, before you build your house, shouldn't you check your architectural plans to make sure that the land is actually yours?
They buy it.
Well, but this house was built in 1946, and the likelihood is these people were not the owners or builders back then. They just happened to purchase it innocently, we'll say, and now are stuck with this. Who cares? And that's okay if that's your attitude. Not who cares, you care.
No, it's bad public policy to like not be able to use the land for anything.
Well, so what would you do though? Then you're going to let it stay?
Yep. Try to get like a variance from the building authority in town.
Okay, so you're going to need to try a variance. You may need to try to work around Title V requirements, so you go to the state. You know, the fact is, though, is that the town may not give it to you, and neither may the state.
Offer to buy it.
Huh?
Offer to buy it.
Offer to buy the adjoining lot. So now I've got to buy, in order to use my little 5,000 square foot lot, I've got to buy the house next door, and buy the house next door, and which is an oceanfront house as well. So all I've got to do is spend another $500,000 or so to be able to use my house. And frankly, your solution is not such a bad thing, right? Because you can't have adverse possession against it. You could grant a potential easement to this house once you own the registered land. There would be ways to go either correct the title to the land court or provide the easement. But in order to do so, I either have to make peace with my neighbor who doesn't appear to want to make peace, or have enough cash that I can buy the other lot. Is this bad public policy?
Yes.
Or it is? Well, what about the old adage that a man's home is his castle? If you encroach upon my land, I have the right to protect it, and I can expect the courts in Massachusetts to enforce that right to protect my home and my homestead.
That's going to supersede, I mean, that well-established right is going to supersede any public policy with regards to this particular exception, simply because of maybe what land value concerns there may be. I think in this particular case, they're going to have to work it out, like he stated, with variances. I think she's absolutely right, with regards to the public policy. But you're going to have to basically undo an established legal principle, which is a man's home is his castle, and I don't think they're going to do that.
So and they're not going to do that, and I know you say, let's work it out, but I can tell you, I have had more than a few where they were way beyond working it out. They had gotten to the point where there was no way, and it seems silly to me and horrible that you would choose to do this to your neighbor. But the fact is, the one in Braintree, the driveway, and it was all on ledge, completely torn up, had to be torn up. That was part of the order. They had no access to the garage to this house after the case was over. And there was no way around it. And you would say, it makes your house look like crap. The house next door, there's a cliff cut into where the driveway is. He'll give you money. Wouldn't it make more sense to take the cash? Give him an easement? No. They had gotten to the point where there was no solving it. A lot of times these things get to the point where there is no solving it. Pools. We talked about sheds. Pools. People put pools, they don't care. And again, they start to dig, they hit rock, they hit something, they say, oh, just shift it 15 feet. 15 feet could mean we're now have zoning violations, or worse yet, we've got the pool, portion of the pool into the neighbor's yard, and the neighbor's not going to allow it to be there. All of those, I have the right to go in and get a mandatory order removing the offending encroachment, regardless of how significant it is, and regardless of the economic waste that will take place there. I mean, if this is the bathroom, this house is done.
I would argue removing the pool, I'm okay with that. The house, no.
Doesn't matter what it is, the Massachusetts rule.
Jim says doesn't matter what it is. Pool, house, bathroom, shed, gone.
Would there be,
Fire escape?
Everything.
Well, real seriously, I walked through the north, we were in the North End yesterday, I walked through the North End, I look and I'm thinking, phew, all of these things are encroaching, aren't they? Things are built too closely together. You look up, whose land is that? We saw the one from the combat zone. The fact is that these are, in the real world, these problems are everywhere. And the fact is, like, I walk through South Boston or the North End, I look at a bow window, I'm thinking, someone's got a dispute here. They just don't know it yet. Right? And so take it out. He says it doesn't matter what it is. No matter what, the garage, the driveway, the bathroom, the pool. And you're okay with the pool, but not the bathroom. Well, so what are you drawing the distinction on? The economic waste, the disparity in value to the injured landowner versus the economic waste that's going to take place? Necessity. Well, so then that, though, rewards the potential wrongdoer, too, doesn't it? Listen, I got to do it, I'll just move it over a little. What the hell, it's only 3 feet.
And if he does it intentionally, then he set himself up to be sued. But these people didn't do it intentionally. They just happened to.
Well, under our hypothetical, they did, but someone probably had a greater understanding. 465, that's not what we would call a de minimis encroachment, right? De minimis, we're talking about inches, potentially. 465 square feet on... That's 10% of this lot. That's not that small. The likelihood is it is living area, kitchen, or bathroom. This is likely to cause havoc. How many of you like the rule? No one likes the rule? See, you know what I think when I read this case, because I thought the dissent has it wrong. Judge Toro's a great judge, was a great judge. But I think he has it wrong because he says, oh, it's too bad. We should be able to do something here. Don't you like a little cold black letter law for a change?
yes.
It's cut and dry, right? There's no gray here. If you encroach against registered land and it is not a de minimis encroachment, out it goes, regardless of the potential extraordinary economic waste that takes place.
I've seen so much gray lately, I don't like to see the black and white.
You like your shades of gray more? See, I sort of like a definitive. I mean, I remember the case, and I've had to use it, and it's nice to be able to argue that there is some definitive boundaries as to what the law says can happen against our homes. Because this is an extraordinary remedy that the plaintiff is granted. And the consequences, the court could care less what those consequences are, no matter how harsh they are.
I think at the very least a balancing of one of these two parties knew that was the case. Either one of the parties was negligent or their attorneys were negligent with regards to giving them title, which apparently were defective, or the party knew that was that way, and then when this new party comes in and moves in, now they want to make an issue of it simply because I guarantee there's some kind of dispute that underlies this whole thing.
That's right.
So whoever failed to act originally on this should bear some of the burden on that.
But here's your problem, right? 46. This is 72. I'm not so sure that either of the parties that are presently the parties to this dispute had anything to do with how this came about. What these oftentimes come to light in the modern world is when properties are changing hands. And there is what we pejoratively call it a windshield survey, which just means someone goes by with the plot plan, looks out the windshield of the vehicle, sees if it's close. The problem is, you as the buyer have no assurances with respect to whether things are where they're supposed to be on that. The fact is, if you really want to figure it out, make sure everything's where it should be, then you need to have a survey done when you buy your house. How many people have an extra couple $1,000s when they're buying a home to now go out and have a survey done of the property to make sure everything is where it's supposed to be? Because, huh?
It's worth it.
Well, does that mean you need to recommend to your clients to do it? When they're purchasing a home, are you having a survey done to make sure things are where they're supposed to be?
Not that I like this case, yeah.
Huh? So when someone calls you and says, listen, I need some help, I need a purchase and sales agreement done. You say, okay, I'll be glad to help you. You're going to sit down with them and say, now you should have a survey of the property done so you know everything is exactly where it's supposed to be. You are going to have that conversation? So where am I going to get that extra $2,000? Huh? That's your problem, but you need to provide that advice?
Yes, you should.
Say, what do you guys say?
I was gonna say, I don't think we need to, but I mean, probably should.
Well, let me ask you, if I bought into this, and you were the lawyer that helped me buy the house, and you never told me anything about a survey, I mean, these people who are having 465 square feet of their house torn down, and may render that house and lot completely unusable, right about now, they're looking around for who's going to share in this loss, right? So should you have told them when they came in to do that P&S is that you really should have a survey of the property done?
Yes.
So you did tell them that?
I would tell.
Yeah, I think you should. Here's the problem, though. Realistically, a lot of times, people don't have another $2 or $3,000 lying around. And for what? Because it's safety, but it could be okay.
But it all depends. I mean, they're buying oceanfront property in Marshfield, a couple of grand.
Should spend a couple $1,000, and especially on a relatively small lot. And that should impact your thinking as well, right? You know, it's one thing, okay, you're on an acre-sized lot, your setbacks, everything looks relatively good. But if you've got some of these other issues, the pool, the close to the lot line, the small sideline between houses, like, the example I used up in Salisbury, you go and you look and things are built virtually to the line. You know that this is not the first or last problem along that stretch of the beach with respect to neighbors saying, hey, air conditioners, right? We've got one of these cases where the air conditioner can give too much noise, and the fact is, if it extends too far out the window, that potentially is encroaching as well. So again, I'm wondering from the standpoint of you practicing defensively, worrying about getting sued when you leave. Does this case also say that you should be giving advice to your clients along those lines of, are you comfortable everything is where it's supposed to be and that there's no issues with respect to the pool or, I think maybe this is significant. This is a huge portion of the house that's in the wrong spot.
I think maybe it's a good idea if you see that there's an abutting piece of land that's registered, that's a definite red flag to really push the idea of a survey and otherwise talk to your client.
How would you even know that though? Right, so you're going to run the title to the surrounding properties? You go ahead.
I think if you look at the layout of your property that you're buying and you can eye that something looks close, that you need to tell them okay, maybe you should get a survey. But if you're eyeing it and it's not that big of a deal and it's pretty far away, I don't think it's that important for you as a lawyer to make that comment.
But how do you know as the lawyer things are either close or not close to the sidelines or where they're supposed to be? Because you're looking at it.
When you sell a house or whatever, isn't there a layout of your property that you get a map, a blueprint that the town has?
But you're getting that at the end. And I'm wondering, in the beginning of the process, when you're thinking about the P&S and you're telling them that they need to be careful here, because you're right, at the end, what we get is it's really just a plot plan. It's $200 or $300, and someone goes down and gets the plot plan from the city and the building permit and looks to see if things are reasonably where they're supposed to be. But you are told, do not rely on this. This is simply for mortgage purposes, and the fact is, it may or may not be reasonably accurate. But especially if you know that it's a small lot, the problem is at the beginning of the process, you don't know any of this, right? You don't know these problems. You don't know the adjoining land. And I'm wondering whether, as a general matter, we have to start giving out advice about, it's a good idea, as a general matter, to get a survey. Most people don't have that money. And I tell you, I've done a lot of real estate transactions. I can't think of more than a couple where the surveys were actually done, and they were done because we thought we had problems. And that's the other part of it. Who the hell wants to invest $2,000 on a survey and then say, no, I'm not interested in purchasing the home? So if it's a problem, how come I've got to advance this money on a deal that may not even go through? That's the other part of the sell that you've got a problem with is, so you want me to pay $2,000 just to see if I want to go further with this deal? Because if there's a problem, I have no ability to rectify it. I'm not the owner. I'm not even under contract with it.
Well, why can't you just go to the Registry of Deeds and see if there was a previous survey done?
The surveys are not on file.
They're not?
No. You get the plot plan at the city, which should show where the house is supposed to be located. But again, I've had a bunch of those where that's where it was supposed to be located, and the builder got out there on site, and things moved because of facts on the ground. And that,
You can eye it.
huh?
I don't think you can eye it, that's why engineers do it.
It is right. That's why engineers and surveys. That's why it's an expensive process. So wait a minute. There was someone over. Brian, did you have your hand up?
Actually, I just heard just a point. When I bought my house, I didn't realize there was an easement on there. If I hadn't talked to the owner, I would never have known because it was never recorded. That's just what we're talking about here.
Yep.
If you don't know that.
Well, and it is the problem is you don't always know, and you can look at it. And again, I told you, if you looked at my neighborhood, you'd think everything is rectangular and straight. And I know the builder, and I've seen the plot plans. My lot is relatively it's trapezoidal, but things are where they're supposed to be. I know my neighbors because he brought me the whole development time, and I said, "Geez, Tom, I don't know. They all know what this looks like?" Because I could guarantee you some of the entrances to the driveways are absolutely not on their own land, and I don't think there's any easements that provide for it. It'll be picked up sooner or later, and especially if there's a neighbor dispute, it'll be picked up sooner.
If you were to grant an easement, which is basically a right-of-way,
Yep.
and record that,
Yep.
you actually still own the property, correct?
Yep.
All you're granting is the right-of-way, right?
Yeah, an easement, if the parties are agreeable, the easements are a relatively simple thing, and I've done them for more than a few, where this problem has come to light, the neighbors are not fighting. Usually, oftentimes, neighbors will do it without even an exchange of compensation, because that's the way they understood their land, their limits of their land was anyway. They still own the land. All it allows for is the ability to cross over it and to be able to leave the driveway there, and if it has to be removed, it has to be removed for whatever purposes, then the person using it will fix it. I mean, you need some provisions in there regarding it, but it can be a relatively simple process. People sometimes get hung up about what it means. It's not a power line utility, it's the right to egress and access. And so it can be relatively simple. The problem is that some lawyers would advise that it could potentially involve then a transfer of the property, and you have an alienation clause in your mortgage that says if you alienate all or a portion of the property, they can call the mortgage due. And so some people would be concerned, well, the better practice would be that if you're going to grant a mortgage, you should get the permission of your lender to do so. And sometimes that can slow the process down. That's the better practice, because otherwise the person granting the easement potentially is at risk that they'll call the mortgage. It's in these times it's not a problem. back when interest rates were 16, 17%, 12%, and you had a low mortgage, lenders would be looking for any reason to call the alienation clause in to make you remortgage at the higher rate. These days, because interest rates are low, and the likelihood is that they're not going to, if they don't find it a significant portion of the property that's being affected. But they potentially, the mortgage lender would have the right to call a mortgage, even upon just the grant of an easement under the alienation clause in the mortgage. So let's just finish with this case. You can't have adverse possession. We don't care how big this is, because there's a language here about a de minimis. What would be considered de minimis? Because this isn't. This is a relatively significant. It says here on page 94, and then goes to note 3. It says, the invasion of the plaintiff's lot is substantial and not de minimis. Note 3. What would be de minimis?
Anything the court seems trifling.
Anything the court feels is trifling, and I think if you think about what they mean by that, we're talking inches, not feet, and potentially it could go on for a significant length, because the note, it is well established that injunctive relief may be refused where the plaintiff is guilty of estoppel or laches. But we already ruled those two out here, and that's why, again, you look for it. Or where the encroachment is small or slight and thus within the de minimis principle. So we're looking at a small or slight encroachment in order to classify it as de minimis, or where the plaintiff refuses to consent to acts necessary to removal. So obviously, to remove the encroachment requires going onto the land, and that becomes, you have to grant permission, otherwise we've got a trespass as well. You do have this Laughlin versus Wright machinery case at page 97, because while it says earlier in that page, each case depends on its own circumstances. The court has discretion as to what they're looking at with respect to removal here. And then it lists the Laughlin versus Wright case at the bottom. Injunction refused where encroachment was upon a 6-inch strip of plaintiff's land, and the removal would involve large expense for the defendant without any benefit to the plaintiff. So the economic waste argument has to be really, really significant for the court to entertain it. Otherwise, what they're looking at, if they consider it de minimis, and de minimis we're talking about inches, it may go on for a couple hundred feet, but it's a de minimis is a small or slight encroachment that really is of no value to the plaintiff, and the cost to remove greatly exceeds any value. You're talking about drain pipes potentially. I could see the argument on a fire escape as being a de minimis encroachment, but we're talking about small encroachments, 465 feet. We don't necessarily have to like this result. I think it is a solid victory for a homeowner to know that regardless of this economic waste argument, the plaintiff has the ability to be able to remove this, even if it causes an incredibly harsh result to the defendant. And it's not uncommon. We have this is not atypical of the cases you'd see in Mass. We have tons of cases. There are situations where an entire house has had to be raised, either because of the encroachment issue or the failure to obtain the proper permits and the like. We have a lot of Massachusetts cases where the economic waste argument should seem to take foothold, and the court has no problem ordering these encroachments to be removed in their entirety, even if it renders the adjoining land absolutely useless. So I think its harshness has some appeal simply because it is one of the few areas I think we see in the law where there's a pretty solid line as to what's black and what's white. And the fact is that you can't have registered land, you can't have adverse possession against registered land, and B, an encroachment that is not considered de minimis, a landowner has an absolute right, regardless of what its use might be, to have that removed in Massachusetts. And it's a very harsh result. It potentially causes significant economic waste, but it is the law in Massachusetts. So I think it's an interesting case. It's interesting in part because of how harsh the application of the rule actually is. And oftentimes we would see courts, as Judge Toro suggested, go out of their way to try and alleviate some of the both economic waste and the harshness of the decision. And our Supreme Court doesn't at all.
Does New Hampshire have this?
I think New Hampshire, all states have similar rules with respect to offending encroachments. I'm not sure any one is as significant and harsh as Massachusetts. My guess is, though, if I were to think about the live free or die state, right,
It's changing.
huh? It is changing because of us massholes that come to New Hampshire to live.
Interlopers.
The interlopers, as you would see it. While it's changing, it actually is a rule that we're not alone, but I think this is a particularly harsh case, especially in view of modern sewerage requirements that Massachusetts has in Title V. The likelihood is that this relatively small adjoining lot could be completely useless if in fact, that's part of the facilities we're taking out here. So, interesting case, I think. See you guys next time.